Sakshi TV special immigration talk show with attorney Ms. Prashanthi Reddy. Please note that Sakshi TV now has 5 immigration shows every week: on Mondays with Somireddy Garu, on Tuesdays with lawyer Srinivas Kaveti, on Wednesdays with Prashanthi Reddy in English, on Thursdays with Chand Parvataneni, and on Fridays with Banu and Indra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on the show is not for general advice. It's only for general advice and not for legal advice. So if you have any specific doubts, you can definitely log on to Ms. Prashanthi Reddy's law firm, which is www.reddyesq.com. They have a wealth of free information and online tools for the hands of immigrant community. So please don't forget to check their website and their law firm. So without any further delay, let us welcome Prashanthi Reddy Garu onto our show. Ms. Reddy, welcome back, Andy. I hope you're doing well.
I am Shivani. Thanks for asking, and it's good to be back.
Yes. So Ms. Reddy, this is, and even the viewers, I want you to know that this is basically like a continuation of the previous episode that we had. So Ms. Reddy, before that, do you want to get into any latest immigration updates?
Well, the update that is the latest update as of last week was that H-1B second lottery has been announced, and that is brought about a lot of excitement among a lot of people because they now have a chance of filing, their H1. If they have not been picked in their last lottery, they might have been picked in this lottery selection. So important to reach out to your employer. If you're an employee, reach out to your attorney if you're the employer, and see if your immigration case has been picked in the second lottery. All the results, I would say, have not yet come out. They're still trickling in. We hope to get all the results maybe by the end of the week, and we expect to see an announcement from USCIS that they have released all the results. And you have 90 days to file your H-1B once you receive the notice. And on the notice, it will give you the last date to file. For example, if you received the notice on August 7th, the last date to file will be November 7th. So that's 90 days. And if you don't file within the 90 days, then you're out of luck, unless you have exceptional circumstances under which you can show that you didn't file. And why you didn't file, then it's possible that they might accept a case after the deadline also. So that's, I think, the headline for this week and last week, the second lottery, because that was much anticipated and everybody was wondering if there will be a second lottery or not.
Yes. Ms. Reddy, so last time we did you did cover a lot about the family visas. So this is, like I said, a little bit of like the continuation of it. So my first question to you is, what happens if one of the family visas petition is denied? Do they get to have an appeal process for it?
Right. So, Shivani, just for a quick recap as to what we did last time, we talked about all the different types of family cases. I think, talked about the priority dates, how to look at the priority date. We talked about how to file a petition for, I-130 and 485. Now we are getting into a little bit more specifics on the same subject. So that was a good question with reference to what happens if you get a denial. And it's, not unusual for people to get a denial, especially if you file on your own. Sometimes that can happen. Say you don't submit the proper documentation. For example, I had a case recently where they filed on their own, and then there was a request for further evidence, and they asked for a birth certificate or some secondary evidence, and they didn't provide the proper secondary evidence, which is usually required in lieu of a birth certificate, because they didn't understand the RFE or the requirements properly, and they denied the case. So there can be other reasons for denial also. Maybe you didn't fill out the form properly. You didn't give information that was required properly. For example, if you were say, arrested at some point of time, or you were in some kind of a trouble with the law and you don't disclose that in your form, and you just say there are a lot of questions in the 485. And if you just say no, no, no to everything blindly without reading what the question is, and it's very easy for them to find out if you've been arrested. So if they find out that you have been, that will lead to a denial, most likely. There is some exceptions. For example, if you have a criminal case, if it's a misdemeanor, that is a petty offense with no jail time, then it's possible, of course, that you can appeal that. So what happens if there's a denial? No matter why you got a denial, you can file an appeal for a denial. You have to file the appeal within 33 days if you receive the denial notice by mail. They give you 33 days to file the appeal. The appeal is filed with the Administrative Appeals Office. You can also file a motion to reopen, and that motion to reopen is usually filed with back to the USCIS office. So a supervisor looks at it. It's kind of a second glance at the denial. But the best, I think, would be to file an appeal, because a motion to reopen is considered to be part of the appeal. So they'll first look at it in-house within the USCIS to see whether it's approvable or not. And if they still think it's not, then they'll just send that. Then it's looked at by AO, Administrative Appeals Office. Now you have to remember, on an appeal, there has to be some reason for you to appeal. So it has to be because you don't agree with a factual finding. Maybe they've incorrectly determined some fact, or incorrectly, not properly looked at some fact, and then they decide that, incorrect factual scenario in a case. For example, maybe you entered on a certain date and they actually think that you entered on a certain date because they're mistaken, right? That's a incorrect fact. Also, it could be that they misinterpreted the law. USCIS does that. They don't, sometimes they go as per their own processes, and they don't, look at what the actual law is. So that's why attorneys are here, and that's why there's an appeal process to remind USCIS of what the law is, right? So you can file an appeal based on an incorrect application of the law or an incorrect law by itself. So there are many ways, and sometimes maybe you did not submit a certain document and that's why they denied the case. But it's possible that at the time that they asked for the document, you did not have it or were not able to obtain it. Then you can file an appeal saying that, here, sorry, I couldn't submit the document then, but here's the document. I was able to obtain it, and this is why I was not able to send it the last time. That also could be, grounds for an appeal or a motion to reopen. So if you don't have any grounds, then, you can still appeal. You have to pay the fee again, right? And you most probably have to pay the attorney fee. So you would want to appeal only if you have decent grounds, I would think. But some people appeal because they just want to gain time, right? So if you have the appeal petition pending, you don't have to leave the country. So if you have no other status, say you filed a 485 family-based, based on your spouse or whatever, and it gets denied, if you don't appeal, you have to leave the country immediately, because unless you have some other underlying status. But if you appeal, for the time that it takes for them to respond to the appeal, finally adjudicate the appeal, you can remain in the country. So some people appeal just to gain time, so that perhaps during that time you can find some other solution, or maybe you can refile, whatever it might be. Sometimes it might be beneficial to remain in the country for some more time, so that you can figure out what your options are.
Yes.
So yeah, appealing can have some advantages as well.
Yes. Do you want to go into the advantages, or do you want me to ask a different question?
No, I just wanted to say that the processing time, I was just going to talk about the processing time. The processing time for the appeal is about 6 months. It can sometimes take a year, can be longer. You have to keep in mind that depending on the reason for the denial, most often than not, AO does not overturn the decision of USCIS. So unless it's a matter of you sending documents which you didn't have before, then it's possible that they'll approve it. But if it's a discussion on the law, mostly AO doesn't overturn these decisions. So in a lot of cases, your appeal may not be successful. So you have to know that before you start the process and not have too many expectations that appeal will get approved. So that is, some information on the appeal, how you can do it, how to do it, and what to expect from it.
Yes. And now let's talk a little about the K1 visa, Ms. Reddy. So what exactly is this K1 visa and how is it different from other visas? Plus, what is the process of bringing, if let's say somebody wants to bring their fiance, so is that something related to this or is it something brand new?
So the K1, the fiance visa is something that you can do if you're not married. So if you're married, you won't file the fiance visa. So the fiance visa is actually a non-immigrant petition that you're filing. It's not a green card. So you'll file this non-immigrant petition by filing the form I-129, and you have to prove that you are indeed engaged and you plan to get married after coming into the country, within a certain period of time. I think it's within 90 days that you have to file the actual immigrant petition after filing the K visa, and it gets approved and you enter into the country. I must say fiance visas are very difficult because they just like to deny them simply because, there's no ceremony required, right, to be someone's fiance. There's no document that is signed. There's no marriage certificate. Anyone can be anyone's fiance. So there's a lot of fraud involved in those cases. So USCIS doesn't like to approve these cases. They usually say, look, go ahead and get married, and then, we'll submit your immigrant petition and we'll look at it. That's usually the attitude that USCIS has. I do understand that in some instances, maybe it's not possible for the US citizen spouse to go back to their home country or to the country where their fiance is and get married. And I guess that's the purpose of the fiance visa, so that the fiance can then come to the US and then they can be married in the US. But just a point that I was making is if you can avoid filing a fiance, you should, because it's more difficult to get approved, and there is a process, and there is processing time, and there is a filing fee. So after you do all that and it gets denied, you're better off just filing the immigrant petition, unless there's some special circumstances under which you cannot be in the same country and therefore you cannot get married.
And also, Ms. Reddy, I want to ask, are there any special consideration or consequences that, there are for different countries or even situations? Do USCIS, sometimes just be sweet enough to just kind of consider some situations? What are your views on this?
So generally, with reference to family-based immigration, yes, it makes a huge difference which country you come from. That's the first point of differentiation, because the priority dates are different for different countries, right? For example, for Indian nationals, the priority dates are backlogged for family-based cases. For worldwide, other countries other than, Mexico, China, and India, the countries which are backlogged, for other countries, the priority dates are not that backlogged. Depending on, which, like, for example, permanent resident spouses, F2A, they're not as backlogged in other countries as they are in India. So yes, the country that you come from, and depending on the demand and the number of, for example, if you're from India, the number of Indian nationals filing for that particular family-based category, if there are more number of people filing than there are green card numbers available, then that's a huge disadvantage for you to be an Indian national. So yes, nationality makes a big difference. Also, as you said, with reference to processing, like we were talking about the fiance visa, perhaps if you go for an interview at some consulate in Europe, since there are not that many immigrants and non-immigrants coming from Europe as they are from Asia nowadays, there's less fraud as well. And therefore, they're more likely to consider your fiance visa application favorably, when compared to, if you go for an interview in, say, in India. So yes, that also makes a difference with reference to which country you're from. The consulates often keep a bunch of things in mind, especially fraud and number of applications that they receive, unfortunately, when they decide to approve the case or not. So yeah, country does make a difference.
Yes. And also, Ms. Reddy, a lot of people just have this myth saying that, once if I marry an American citizen, or I'll immediately get the green card and immediately be the citizen of the country. Is that really true, Andy? And how is that effective? How much of it is true?
So, not true, meaning that you don't immediately get even a green card. Some people think they automatically become citizens. That's definitely not true. But you also don't immediately get a green card because there is processing time for everything. Now, there is no visa number non-availability because there's no caps. There's no green card caps for immediate relatives, which is what a USC spouse is. That's an immediate relative. So there's no waiting time with reference to the unavailability of numbers. You don't have to go look at the priority date. You don't have to look at the visa bulletin to see whether your number is available or not. So there are no delays in that regard, but there are delays with reference to processing time. And even more so if you are outside the country. So there is a difference in process if you're in the country, if you're outside the country. If you're in the country, you're married to a US citizen, then at least you can file an I-130 and 485 simultaneously. And even though you may not get the green card immediately, you will get some incidental benefits to filing the petition. So while the petition is pending, you can get advance parole, meaning you can travel without a visa and come back. You can get EAD, which is employment authorization. Even that, there's a processing time. It can take 4 to 6 months, sometimes takes longer, sometimes takes more, but at least it's not as long as the green card takes. Having said that, I must say sometimes family-based petitions, especially if the person is in the US, do get approved in 3 or 4 months. So it basically gets approved, the green card gets approved before the EAD or the advance parole does. So yes, it's definitely better when you're in the country. Processing times are lower, and even if you don't get the green card, you are at least here and you have incidental benefits. Now, if you're outside the country, you cannot come in until the green card actually gets approved. And it has to be approved in 2 stages. You have to file the I-130, and once that is approved, then you file the immigrant visa petition. And for both, the processing times are pretty long. And after the immigrant visa petition gets approved, then you go to the consulate in Mumbai, and there is a waiting time at the consulate for interviews. So all in all, it takes maybe about 2 years to finally get your green card if everything goes well. So it's not true that you can immediately immigrate to the US simply because you're married to a US citizen.
Yes. And also, Ms. Reddy, I kind of wanted to talk about this family-based visas. A lot of people, they just come over to America, which their H-1Bs, and also they have their kids here, which makes them, the permanent residents, basically. And again, nowadays, there has been a kind of buzz saying that a lot of people who are about 21 are supposed to leave the country now. So, what do you think, Ms. Reddy? How is this kind of nuisance creating a buzz in the people? People are actually scared that, okay, I have to leave the country. So, how much of it is true?
So if you're talking about dependents turning 21, is that what you're talking about?
Yes.
So yes, if a dependent turns 21, it really depends then on if the 485 was filed at the time that they turn 21. If it was already filed, then there is no issue. If they are still waiting for priority dates and their parents haven't filed for their application, and therefore the children's application also is not filed, then they're out of luck. Unless, again, there are some exceptions. CSPA, Child Status Protection Act, which means that they deduct the time that it took for the USCIS to process the I-130. And, within that period of time, after deducting that time, if then your age is under 21, then you can still file. So there are some exceptions to the rule, but in general, the rule is that you have to be under 21 to get the benefit of being a dependent, a minor, right? In order to get the green card with your family members. That also applies to H4s, by the way, or any other non-immigrant dependents once they turn 21. They have to either leave the country or they have to file a change of status. So they don't necessarily have to leave, but they have to do something. They can't just remain in the country because they will be out of status. So a lot of children file for F1s, student visas. And if you're old enough, you could possibly file for a H1 as well.
Yes.
So
Ms.
there are
Reddy,
ways of implementing. Yeah.
yeah. I'm so sorry to cut you down, but again, can you also talk about what happens to the people who get divorced in the US? Let's say somebody married a US citizen and now they're getting divorced. What is the deportation process, or sorry, not just exactly deportation, but what exactly is the after process like?
Yeah, so if you marry a US citizen and then you come in and you file for your adjustment, depending on what the situation is, right? If you're outside the country, you marry a US citizen and you come on a green card, then there are no issues, even if you get divorced. You do get a temporary green card for 3 years. That is correct. So after the 3 years period, you have to show that either that you're still married, or you have to show that the marriage when it took place was a bona fide marriage and wasn't a sham marriage. Right? So you didn't marry just for the sake of getting a green card. If you're able to prove that, then they waive the joint filing of the, converting the temporary green card into a permanent green card. It has to be filed joint by both spouses. So they waive that requirement and they allow you to file, as a single person.
Yes.
The divorce doesn't have to be a reason. It can be a no-fault divorce. Or it could be that there was some abuse taking place, something happened in that marriage and, there were issues. So whatever it may be, as long as you're able to show that at the time of filing it was a bona fide marriage, you should be okay. So that's that. So depends. Again, now say that you got divorced while the proceedings were in process, meaning that your 485 is pending and even before it got approved, you got divorced. In that situation, then if there's some exceptions. The exception is if there is spousal abuse, if there's domestic violence kind of situation, then you can still adjust by filing a different I-360 application for under VAWA, Violence Against Women's Act. So there is some relief there. But otherwise, if there are no issues, unfortunately, your 485 will get denied. And you have to make sure that you maintain, that's why your underlying non-immigrant status before you file for adjustment.
Yes. And also, Ms. Reddy, I kind of wanted to understand that what actually do you see when it comes to these kind of family-based visas? Number one, what is the common things, common mistakes that people tend to do when they're applying for these, and what cases do you generally deal with when it comes under the family-based visas?
So a lot of people file family-based visas for spouses because those are the immediate relatives, right? The other types of visas, we can't file because the visa numbers are not available. So generally, we tend to have a lot of filings for permanent resident spouses because sometimes the priority dates are available for those kind of cases. We have US citizen spouses. We have US citizen parents cases and US citizen children. So those are the most common cases that we deal with. And in most of these cases, it's pretty straightforward if you know what you're doing. And if you diligently fill out the application, which is difficult to do unless you have practiced in doing that. Because the application is like 22 pages long or 20, I forget now, 23 pages long. So if you're not filling out each part and each question that they're asking has a consequence and has a reason behind why they're asking it. So if you don't understand the reason behind why they're asking it, you will not be able to fill it out correctly, number one. Number two, there's so many columns that have to be marked, so much information that has to be put in, that it's very, very easy to miss columns or to miss information. And if even if one column is missed, the entire application comes back. And especially if you're on a deadline, meaning if you have to file in that particular month, or if the person is falling out of status, something like that, then you may not have an opportunity to refile in some instances. So that itself makes it challenging to file the case on your own.
Yes.
And I see that when people do it themselves, these are the common mistakes. They send it to the wrong center because it's not intuitive as to where you have to send it. They keep changing that every month, literally. They send the wrong checks. They write the wrong checks. They sometimes write a different thing in words and a different thing in
I
numbers.
think the most common one is the dates, because we have
And the dates.
the date, the number,
Yes,
the month,
correct.
right? That's
Right.
apparently very common.
They get mixed up with the month and the day. Put it in the reverse, the British system or the Indian system. So all these things can cause problems. But when I see people coming to me, what I often see is that they don't have supporting documents. They don't have birth certificates. So we have to submit birth affidavits. That becomes a problem. Sometimes I've seen issues where they're traveling to Canada and Mexico and they didn't get stamped. Their last entry was not stamped in their passport, because when you travel by road, sometimes when you're going on a vacation or something, they don't bother to stamp your passport. And then we have a huge problem because we need to show the last I-94 and they don't have it. So sometimes either they have to go back to CBP and ask for the I-94, to show that they entered with inspection, because that's a requirement for any immediate relative petition, that they entered legally. And if they're not able to show that, then they have to go back to CBP and, try and get an I-94, or they just have to leave and come back again. So that there is, the last entry can be recorded. So also I see sometimes birth certificates are registered late. Birth certificates don't have a name on them at all. Birth certificates have a different name on them. So there are ways of dealing with all these kinds of issues, definitely, and ways of overcoming them. But these are the common, I think, issues that I see with family-based cases.
Yes. And I think with that, we'll have to end today's session early. Thank you so much for tuning in. Thank you so much for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you, Shivan.